Thank you again. In this presentation, I have been asked to give an overview of the state of play of migration in Europe. I'll try to do this in three ways. First, I would like to speak about the numbers, providing an overview of some of the migration trends in Europe. Second, I will outline the legal frameworks being developed by the European Union to manage migration. And third, I'll provide an overview of some of the cross-cutting trends and issues in the area of migration. According to Eurostat, during 2011, there were an estimated 1.7 million third country nationals immigrating into the European Union. By third country nationals, we mean nationals of non-European countries. In addition, 1.3 million people previously residing in an EU 27 member state migrated to another member state. Relative to the size of the resident population, Luxembourg recorded the highest number of immigrants in 2011, followed by Cyprus and Malta. The foreign population in the EU, meaning people residing in an EU 27 member state with citizenship of a non-member country on the 1st of January of 2012, was 20.7 million, representing 4.1% of the total European population. In addition, there were 13.6 million persons living in an EU 27 member state on the 1st of January 2012 with citizenship of another European Union member state. Having peaked in 1992 with 670,000 applications in a European Union at the time composed of only 15 countries, and again in 2001 with 424,000 applications in an European Union of 27 member states now. The number of asylum applicants within the European Union fell in successive years to just below 200,000 a year. From this relative low point, there was a gradual increase in the number of applications, and by 2012, the number of asylum seekers in the EU 27 reached just over 320,000. This increase is partly due to a considerable high number of applicants or asylum applicants from Syria and to a lesser extent from Russia, the Western Balkan countries, Albania, Macedonia, Bosnia and Herzegovina, Pakistan and Georgia. Legally speaking, the European Union offers a very interesting context for the study of migration law. Despite the very different migration contexts and realities in the various European countries, and despite the varying cultures of human rights and mobility, the Union has many legal instruments that apply across the board. Internally, the Union is a single market, a single legal space, so to speak, with European nationals able to travel and reside in different European countries without problem or hindrance. In the most part, internal borders have been eliminated, creating what the European Commission likes to call an area of freedom, security and justice, a borderless zone in which people can travel without having to use their passport or identity card. What this has meant, however, is that the EU has necessarily had to focus on closing the external border, as anyone who manages to enter one country effectively has access to all the others. This translated into the need for harmonized efforts at the external borders, reflected in the Common Borders Code, the Common Visa Code, the setting up of Frontex, and common European laws on a variety of migration-related issues. The European Union has developed harmonized standards on a range of issues, from asylum to family reunification, from economic migration to highly skilled migration. I will focus mainly on how the European Union deals with forced migrants, but a general overview of other areas of migration law in Europe are worth noting. First, as mentioned briefly, EU nationals enjoy freedom of movement. They are able to travel and reside in any European country without difficulty. EU nationals should enjoy equal treatment with nationals of the country to which they migrate. Now, in practice, we have seen problems in how this is actually implemented. If we look at the way Romanian nationals and Bulgarian nationals have been treated recently after Romania and Bulgaria joined the EU, the imposition of transition periods on certain countries, they all reflect a certain certain antipathy against particular groups. Moreover, a whole series of laws have been promulgated to regulate who gets the right to live in Europe and for which reasons. The development of the EU Blue Card, which is basically a directive regulating how highly skilled migrants can come into Europe and the benefits that they get to move within Europe, was a way for the European Union and its member states to seek to attract highly skilled migrants, which Europe needs, whilst efforts have been made in the context of family reunification, migration for the purposes of study, and migration for the purposes of research. As I said, I want to focus primarily on the context of forced migration, specifically refugees and asylum seekers. The legal context regulating forced migration in Europe starts from the international law and the various instruments adopted by the United Nations and the Council of Europe. Obviously, the Geneva Refugee Convention is a critical tool within the European framework as well. It was created primarily to deal with forced migrants in Europe at the end of the Second World War. Foremost amongst the instruments of the Council of Europe is the European Convention on Human Rights, which amongst many other things prohibits torture, cruel, inhuman and degrading treatment, and through that therefore prohibits refoulement, or rather return, to countries where there is reason to believe that serious human rights violations will befall the individual. Developments in Malta over the summer of last year clearly highlighted the role that these provisions can play in holding national governments against standards to which they have agreed. When the Maltese government threatened to send people back to Libya on the 9th of July of last year, an interim measure applied for by the People for Change Foundation, with the support of other NGOs, stopped the government from doing just that, thereby preventing the return of individuals to Libya where their life or freedom would have been threatened. In the context of forced migration, the European Union has developed extensive legal frameworks, developing the most detailed of regional legal frameworks around the globe. The so-called Asylum acquis, which is largely European lawyers speak for European refugee law, creates what is known as the Common European Asylum System. The origins of the system can be traced to the Treaty of Amsterdam, which established the European Community's competence in the area of immigration and asylum, and put in motion a process for the development of harmonized standards in this regard. Its first phase was initiated by the European Council of Tampere in 1999. The system has three broad goals, namely increased harmonization, effective cooperation, and solidarity. Harmonization is to be achieved through, amongst other things, common, legally binding rules on the interpretation of the Geneva Refugee Convention. The development of common minimum standards was to be extended not only to the determination of refugee status, but also to the procedures and reception conditions, was the development of a common system meant that states had to develop a mechanism to determine who was responsible for addressing any particular claimant. Much has been achieved in this regard. The European Union has over the past decade established minimum standards regarding the interpretation of the Convention definition of a refugee, created subsidiary protection as a harmonized complementary form of protection, outlined minimum procedural safeguards, and set out minimum standards for the reception of asylum seekers. It has also put in place measures for the determination of the member state responsible for a particular asylum seeker. This is done through the notorious Dublin Regulation. For those who might not be aware, the regulation, under the guise of preventing asylum forum shopping, effectively means that asylum seekers and beneficiaries of international protection usually cannot move to another European country. The system, which has now been confirmed in the recasting of the directive, places undue burdens on countries like Malta and is the antithesis of solidarity. Funding instruments have also been put in place, supporting projects on the national and European level implemented by governmental, intergovernmental and non-governmental bodies. The European Asylum Support Office was set up in 2010. It was established with the aim of enhancing practical cooperation on asylum matters and helping member states fulfill their European and international obligation to give protection to people in need. Some of these measures have been more successful than others. We are moving now into the so-called second phase of the Common European Asylum System, where the European Union, together with its member states, is building on what has been achieved. Over the last 2 years, recast directives have been adopted, amending and developing the existing framework. These provisions are further supported by a series of measures relating to the external border of the Union. As the Union moves towards an area where internal borders are eliminated, the need to have a common and harmonized approach to the external borders becomes increasingly important. Frontex, officially known as the European Union Agency for the Management of Operational Cooperation at the External Borders of the Member States of the European Union, was created specifically to manage the operational cooperation. Since being set up, its powers as well as resources have increased exponentially, and it is now a core feature of the European border regime, in some ways adding its logo to the Fortress Europe model. Beyond the operational cooperation, the Union has also developed Eurosur, a system of border surveillance that will include the use of extensive technology to help inform the picture of what is happening at the external borders. And this is worth a comment here. With Eurosur, one of the things that have been promoted about it has been that it can help us identify people at risk at sea to make sure that rescue gets there on time. However, we need to make sure that identifying people at risk will not mean or will not become a tool to returning those people to the countries from which they left, but rather will really be used as a tool to safeguard their interests, protect their lives, and assist them in reaching a place of safety. Let's turn now briefly to the idea of human trafficking. When we speak about human trafficking, we are talking about the movement or keeping of persons by means of coercion, deception, or abuse of a position of vulnerability, with the intention of exploiting such persons. Traditionally, the term has been associated with women being trafficked for exploitation in the sex industry. Nowadays, building on the international law position, the European Directive on Human Trafficking recognizes the wide spectrum of ways in which individuals may be exploited in the sex industry, in forced labor, through forced begging, through enforced criminality, as well as through the removal of organs. When we look at these laws, however, we find that the human rights of trafficked persons are not prioritized. Rather, their immigration status is suspected, and they are protected when, and only to the extent that, their presence in Europe can be of benefit to the prosecution of their traffickers. EU law creates a residence permit to be granted to trafficked persons who cooperate with the authorities. The residence permit, which allows access to a number of services, is a positive tool with significant potential. The potential is, however, significantly hindered and its purpose rendered doubtful by the fact that it is only provided until such time as the person continues to be involved with the prosecution of that case. The message of the relevant directive is clear. We will only help you for as long as you are useful to us, and after that, you're on your own. Okay, having addressed some of the more general points about the legal context, in this last part of my presentation, I'd like to present two trends which have been noted in Europe. First, the criminalization of migration, and second, the commodification of migrants. Over the past decade, immigration law and policy in the European Union and the Western world has more broadly have come to be marked by restrictive tendencies, focusing on the reinforcement of border control, tightening of conditions of entry, expanding capacities for detention and deportation, and the proliferation of criminal sanctions for migration-related offences. These measures can be seen as both the cause and the result of a growing anxiety about migration, which in part at least results from scaremongering by the press, by the public, and the political establishment regarding migrants and migrant criminality. Overall, these reflect a shift towards what has been aptly termed the criminalization of migration, or, more convincingly, the criminalization of migrants themselves. Part of this process of criminalization of migrants has seen the closing of the external borders for all other than the ones we want in Europe. The setting up and work of Frontex, Eurosur and similar mechanisms are only the tip of an iceberg in a system that has made access to Europe ever more difficult for most people. Fortress Europe now has a name, a logo, and significant operational and financial capacity. If we shift our attention to economic migration, Europe has taken an approach partly linked to the economic crisis. It has focused on getting the workers we need, for the time we need them, to do the jobs that we need them to do, and in which European nationals are unable or unwilling to do. This is a reflection of the commodification of migrant workers, a process whereby migrant workers continue to be seen and valued as economic units of production rather than as human beings. Frisk's words, "We wanted workers, but we got people," seem to resonate strongly in this context. Unfortunately, the realization that we had got people has hardly been accompanied by a shift in attitude and rights to be afforded to migrant workers. The scaremongering against migration on the basis of the limits of the labour market